Thank you, everyone, wherever you are in this moment. Probably it's good afternoon or evening in Finland, but it can be everywhere because in any case, we are recording and broadcasting afterwards this seminar. This seminar is for you, startuppers, innovative businesses, investors that are putting resources on new digital and tech and innovative businesses. My name is Andrea Chmielinski Bigazzi, and I am the coordinator of PrivacyRules. Here with us, you have members of our alliance from a variety of countries, from Finland, from the Czech Republic, from Canada, from Poland, and from Ukraine. They represent the various pillars of PrivacyRules. Our expertise on anything that concerns data protection, cybersecurity, and data-related communications is in fact based on three types of expertise: legal, cyber, and communications, as I said. So we are ready to assist any company from the very early stage, from the startups all the way up to when you will be in the stock exchange on anything related to data privacy in the broader sense. We are happy to have this event in parallel with Arctic 15. We were supposed to have it after Arctic 15, but they changed their plan. But we had already a session this morning for investors in the course of Arctic 15, and we were very, very happy for that. As I said, here you have all members of PrivacyRules from those jurisdictions. Markus is also the chair of our committee working with startups and for startups. And Christina recently accepted to chair our comprehensive cyber crisis communication program. So she is gathering in our alliance communication companies that can assist on cyber crisis. We want to make it simple and we want to make it very interactive. So those of you who are in the audience, please make as many questions as possible. We want to avoid monologues from all of us. We really would like to engage with you and provide as much as possible tips. And this is also the recommendation for all the speakers today. Please pass on to the audience your live experience. That's way more important than the concepts you want to pass. Actually, tell us how this concept became live and turned into the expertise you gave to companies. Because here in the audience and in the listening, there can be companies that might face the same problems next. So let's be very concrete. I pass the floor now to Markus. I pray Markus to introduce yourself as everyone else. Markus is speaking to us from Helsinki, from Lexia, and virtually Lexia is also the co-host of this event. So thanks a lot, Markus, for making a scene setting and the moderation of our session.
Thank you, Andrea, and also from on my behalf, welcome to this seminar, and it's a great pleasure to kind of host this and co-host this, and of course to try to moderate and also share my own views regarding data privacy in the startup world. As Andrea said, I'm Markus Myhrberg. I work as a partner at Lexia Attorneys in Helsinki, and having my practice around technology, IP, and data. So been involved in data protection, data privacy matters for years, and also having a little bit broader view if we to talk about data and the importance of data. And it's a great pleasure to have Karolina, Filip, Mitch, Gleb, and Christina joining us today. So besides legal knowledge and profession, we do have tech knowledge and communication knowledge here. Because as Andrea said, this is like playing together and building together and together with different kind of actors, advisors, and knowledge. And sometimes, quite often when we talk about data privacy, we do remember legal points, which are, well, okay, we will hear some of those thoughts today. And then the tech side might be at least data security questions. But quite many times, if we talk about this, we might forget data communications. Do you agree with this, Christina? We can't hear you.
Sorry, I was on mute.
So
completely agree with you.
You do?
Yes.
So,
surprise,
why
surprise.
is it so important?
Well, it's all about how you frame it in the beginning. If something happens, and what do you tell others? What happened? That's where the communication starts. And if you go out screaming to people that we are in deep shit, that's what people sort of start figuring out. Okay, we are in deep shit. But if you say, I think we might want to take a look at this first, and then it takes time to label it. And if you are smart, you can actually communicate much better and much wiser, and also make sure that you don't create more risks and trouble in the future.
Thank you. Well said. And so we can notice that besides the lovely regulation and sometimes a bit complicated tech problems, we might talk and will talk today more about also about communications, and especially Christina will tell more about how to build these all together also. But before letting the others to present, so I will share some of my thoughts, and today we kind of have a little bit different points of view, angles where we approach the matters, and we haven't coordinated too much, so everybody has their own views. So we might be a little bit overlapping, but I think we will hear different kind of views from different countries and areas, and have a lively and lovely discussion around data privacy. So now I'm trying to share my screen. Let's see. Probably too many screens here. I assume you see my screen now. Andrea, you do. Thank you. So shortly about today's, because we have in overall our subject is privacy, cybersecurity, and data communications as a part of the game. And I was not sure what will be my title, but we already had a session this morning at Arctic 15, and from there I brought this word, which is trust. I think trust was the key word in the workshop in the morning, and now this is building the trust. And just like why we are discussing this matter today. So of course it is that the role and value of data is increasing. So, and in the future, you might say it's all about data, but of course, how to use it, how to survive. Today, I think we will concentrate more on personal data, but of course there is also other data than personal data. We have to remember, and it's good to remember. Sometimes you even forget it. So the privacy is everywhere, and it hinders all kind of good business, even though it might not, if it's purely industrial data, etc. But of course, the role of personal data is also much more important, and it's everywhere. And to manage and to survive in this environment, of course, you should build all kind of best practices. You need to be aware what you are doing. You need to be aware about the regulation, business needs, and stakeholder requirements. And there was a good question about the potential execution and balancing the risks also already in the morning. is it possible, and is there a good framework or tool for balancing the potential and the risks? And today, of course, I think we will hear more thoughts about how to manage the risks, but at the same time having all the potential around data available. And of course, you have to use the data to create some more value. I'm talking today from perspective of the European side, so and GDPR, etc. Of course, because it is like the European meeting mostly, and all the but whatever said today, if there are startuppers out of the Europe following us, I think most of this, of course, apply also out of the EU. And two words which are used also probably here today are the privacy by design and privacy by default. And I think privacy by design is one of the key words. So plan what you do. And for planning what you do, not always, but for the startuppers, my recommendation is to build some kind of data protection program. It sounds huge, but at the end of the day, it is just you create some best practices, know what you do, and aim to fulfill the requirements. But a little bit more formally, I would talk about kind of framework to help you to manage the handling of personal data and the roles and responsibilities in your company. For the legal purpose, so of course it helps you to demonstrate the accountability, what is one of the key requirements from the GDPR point of view. So you have to be able to demonstrate that you have also done something. And then, of course, build better and better practices. Today, we heard that, for example, regarding data security, the so-called best practices are not enough. It should be more. And this is, of course, one interesting question. What is best practices, for example, regarding data security? Maybe Gleb can talk about that. That is asked quite many times, actually. What is the best practice? Or what should we do? What is the required level? And of course, why we do this? We do this, of course, for building the trust. Building the trust regarding all stakeholders regarding your company. And because we have a limited time today, so I just want to have a kind of brief introduction for your data protection program. And this is kind of maybe before building huge bunch of strategy papers or policies, etc. Maybe you just ask these questions or test if you have knowledge about this, what happens in your firm. So that will be the beginning of your data protection program and in overall your knowledge around health. So starting from what we do, what we have, where it comes from, where it goes regarding the data, what we do with the data, how long we keep it. If somebody asks questions regarding their data, can we answer it? Do we tell how we process? What is our role? And this is actually very interesting question, the roles of in the data protection world. So the controller, processor, controller, etc. Know in which role you act in the world of the data, personal data. So sounds that everybody should know, but at the end of the day, I would say This is one of the trickiest questions sometimes, especially regarding SaaS business, etc. And how we keep up all this and show it, and what we do if and when something happens. And that's, of course, mostly called data breaches in the world of data privacy. So care, prepare, and take actions, and ask if you don't know is my message today. And the second one is, don't mess with your data. I would say this is like legal disclaimer, probably your most valuable asset.
Absolutely so.
Thanks. That was my introduction today. And I think we had the plan to have discussion after every presentation. So very willing to take comments and further thoughts regarding what's already said.
And I suggest actually comments not only from attendees, but also from the other speakers here. So I don't know who wants to break the ice. I already dragged into this role Christina this morning, so I don't know if you want to volunteer through me again this afternoon.
I can always break the ice. I'm the known icebreaker. That's what we do in Finland. Markus, yes, it would be great that everyone is taking care and understanding, but talking about real life, how many startups actually do that?
That's a good question. That's why I'm saying you should have it and start from somewhere. And if you start from just asking these questions, you already have something. If you ask and answer even one of these questions, you have the beginning of your data protection program. That's a good thing. It doesn't have to be too official. You have to be aware that you have to do and know something. And I think quite many actually do that. At least they copy their privacy policy from somebody else.
Yes, but that's not actually doing it. Because yes, we can copy a lot of stuff from others just to show that we have something. But this is all about the processes. How do you behave? What you do?
Exactly.
So how do you get into that level? But because it also, besides the knowledge, it requires skills to do it.
It is. And that's why if you do not have the skills, I always advise to call a friend or ask an expert in this area, of course. And of course, there's a lot of information. But if you just remember that if data is the most valuable asset in the company, maybe you should have all kind of to-dos around it, including data privacy matters. So if you just kind of think what is important and what can create also quite a huge risks that might remind you that something has to be done. And of course, I do admit, and I think some of us has faced the reality that for example, GDPR is not the most sexiest topic to talk in startup meetings. But I think if data is everywhere, so it is also a kind of must, and you can't avoid it.
So we have to think how to make GDPR sexy.
Yeah, that's of course. That's what we are doing today. So,
all right.
Piece by piece.
Okay, guys, help me out. How to make it sexy?
Can I try to stimulate a perspective from outside the GDPR to some extent? Mitch, I guess that probably when you started hearing about the GDPR there in Canada and in North America in general, I mean, you started to say, oh gosh, this European and making another mess. And so how do you react? Because I mean, we cannot have this Eurocentric perspective. Data are going everywhere. Yes, we are a big market, but actually data is processed all over, and a lot actually is focused in North America. So how do you see this?
That's absolutely correct. And I think that, when you're developing a business, you'll want to understand and pay attention to where is your data coming from and where is it going. And obviously at these early stages, you may avoid digging deep into some of these issues, but I think that it's very important to at that early stage in a business. And I think Markus hit it early in his presentation when he talked about trust. I mean, it's such an important interest that you're developing as you build a customer base and as you try to generate more attention to your business, is that trust that you will protect information, and particularly sensitive information. So, especially if sensitive personal information is something that your business is handling, it's just vital to understand and develop some practice with respect to how you're safeguarding it. And in particular, what laws do you need to care about? It may be the GDPR, it may also be other laws too. And I think it's important, there's a lot of assumptions that get made out there which is, compliance with one may mean compliance with another country's laws. And it's not exactly the case. And as I'll tell you later on in my, few minutes, that I spent an awful lot of time Canadianizing other documents. And there are differences, and certainly you'll find that there's differences with, California's, just to give us a privacy legislation, to give an example. So, that's not to say that you need to all of a sudden think about the entire world and develop such a robust privacy policy where you've got different priorities. However, privacy by design is not just a catchy phrase. It's very, very difficult to repair and do patchwork afterwards. So if you see your business actually, obviously we want to set it up for growth and for success. Part of actually getting that trust and keeping that trust is doing this privacy investment at the front end. Yeah,
and actually I catch from there, because the privacy by design, as you said, it is hard to get it afterwards. So it's like, if you build everything wrongly since the beginning, you can't turn it around and have the compliance afterwards. Whatever it concerns everything here. It's really, thank you, good point there. So as I said, the earlier the better, and actually since the beginning is kind of must. Please.
If I can introduce here, there is a question from Leo, and the question from Leo is, how do I know when my company needs to get compliant with another regulation? Data goes basically everywhere. How can I select which countries should I care the most about? That's a very good question.
Will you, Mitch, talk about this more in your presentation?
Yeah, I will touch upon it, but just to not bury the lead, I'll say consider consider your business practices, consider who your clientele is and customer base is, and then also consider what service providers are you using and where is data traveling to and from. When you dig into those questions, you may inform yourself as to where is the data, who might have access to data wherever it goes. And that should provide you with a bit of a clue. Obviously, you should engage experts where necessary. It's obviously a very nuanced area, but I think from an initial perspective, those are important considerations for you to look into.
If I can interject here, I think something really important, where data is and goes. If we put ourselves in the shoes of the startuppers, there are so many things to think about at the very beginning. Having one thing in mind, I need to go public and make money. So probably you overlook a little bit this aspect unless you have tech people inside your startups that are mastering this for yourself. So Gleb, in this case, FirstBridge, your company deals with research and development. So probably you are tasked by startups to develop for them, to study for them. Can you give us a tip? Knowing where data is and goes, is it easy? Is it easy actually to inform the startup management about this?
Yeah, so hi everyone, and thanks for having me. So regarding data, it's actually really crucial what startup is doing, because for some company, they're not actually doing anything specific with the data, maybe only like newsletters. Even like getting username and email is getting data. So for this specific cases, you can use this beautiful softwares that is available like as a service, like HubSpot, whatever. And in this case, what you should consider, which is definitely not always the case for all countries, which is not the case for Europe, for example, but you should consider if the data is actually stored, the servers that store your data is actually located in Europe, in the US, because for some countries in Eastern part of Europe, this is something that should be important. So you always can ask a question from the service providers that you use, actually where you guys store data, are there any other options to store my data? So in the most cases, startups, they don't store their own data on own servers because it's inefficient and just it's harder to maintain. It's much more expensive. So you use services, and for these services, you can just address these questions and you can actually talk it through and actually choose where your data will be stored.
Yeah, thanks, Andrea. Just a note here: was it so that Gleb has to leave at 7? Was it so? Yep. So should we probably change the order a little bit and let Gleb to continue from here so that he will anyway have the time? So just to be sure that you don't have to leave before you have said some additional words. So probably if it's okay. So yeah, I think we change. And please, if it's okay, Gleb, you can share your more thoughts directly from here.
Yeah, absolutely. Yeah, and I'm sorry that I need to leave. This is just a highly important matter. But so if we go a bit away from this point, a bit from data, my topic that I wanted to present for you today is actually that goes directly what my company is doing. So FirstBridge is an R&D company. We're doing a lot of tech development, some deep tech stuff, which is in some cases are really exciting at the end product, which is super boring at the start. But this is part of the whole process. And I really want to bring more light to, in general, to R&D, because a lot of people that thinks that is actually like super complex process. It takes a lot of time, a lot of money, and it brings to nowhere, and only like top companies are actually using this. So I will give you a quick introduction to what it is, why it is needed, why it's even needed for a startup, and how it can actually save your time and money and become a successful part of your business. So you could actually think of R&D as a very abstract process. They may or may not lead to the result, but the truth is that a proper R&D is always clear, specific, and has expected end result. In a nutshell, R&D is a way to reach innovation with a clear understanding of goals and objectives of the planned product. It is actually not always something new. It can be like a non-classic combination of existing technologies that you actually combine to achieve a better result. It can be used for both like brand new products, or it can be actually used to improve your current offerings. It is actually part of everyday operations of both public and private sectors. It gives companies like a competitive edge to stay ahead of the market. In the extreme cases like pandemic that we all suffered from, R&D can give companies a chance to prosper without relying on market movements or even without specific partnership actually to improve your product. But it all sounds really nice, but don't really get me wrong here, because it actually also can harm the business too. So it's not all like, all flowers. If a company doesn't form the end goal, which is actually really popular among startups, because people come to the market with an idea to bring something bright, something new, like to change the world. But these ideas, if they are not formed properly, they could become like money-sucking black holes and time-sucking black holes that will never achieve tangible result. So if you go to the market and you say, I want to create something that no one else in my industry has, is actually not really a great goal, and most probably in relatively short term, it will the R&D process for this will be stopped and marked as failed. But the actual reason for failure is not the process itself, how you approach research, how you do the development, but the objective that you had at the start. On the other hand, for some companies, R&D equals life. That's actually where you want to achieve, where you look to see, like, you want to see yourself at your company at some point there. So the companies like Intel or Nvidia, they use R&D to stay ahead of the market, because they research for innovations constantly. They create new products, they combine their existing products to bring something better to the market. But let me actually get to how it actually saves money for non-Fortune 500 companies. That would be probably the most interesting part, because without even basic R&D, what we really have as an R&D company, from our experience a lot, and what we get from companies that we work for, a company that cannot properly assess the development and what resources you need will actually take a lot of time and money from the development. So a properly organized R&D is a guarantee of efficient use of resources through the entire project. This allows to get away from chaotic development, which is actually a big part of today's world, because especially with the rise of platforms like Upwork, like Freelancer, people go out to the market, they think they have, like, for example, I need to create a landing page, then I need to create like this small backend solution that will bring me some value, and at the end, this is chaotic development where you don't see actually the end goal. You don't use any modeling, and you don't take into consideration like the whole project. So this will actually, this will bring to a non-rational use of your resources. So to bring us back again to startups and how we can actually use R&D in a way to help companies, I want to talk about like 3 different directions of 3 different industries where R&D is used, and where each of those require different depths of R&D. So the first one is fairly simple. Everybody understands this. It's e-commerce is like and super actively developing industries since the beginning of times. It's actually one of the reasons why it's so highly innovative right now, highly technological, and why the R&D in this industry is actually not that deep. So you don't really need anything new. You combine a lot of processes to bring actually the buying experience, the user experience up. So for example, in recent years, e-commerce was actively looking into artificial intelligence. Like, for example, if the company is selling shoes, you can try them on. And also a lot of platforms are trying to implementing new types of payments, so to simplify the purchase process. The second one that I want to mention now is cybersecurity. It actually, a big part of why R&D process in cybersecurity is important, and cybersecurity is actually part of each company at specific stages. You start considering it a lot, and this is because the computing capabilities of hardware is growing, and actually it is much harder from year to year actually to maintain the proper cybersecurity levels, and this is the main fact why you always try to improve it. And the last one from my examples is actually privacy. And what I like about privacy in general, that in this process, it's not, from our perspective, it's not only technical, it's actually legal, right? So the tasks and challenges of the market are constantly changing. So industries really understand that our approach to privacy cannot be the same as even it was like 3 years ago. Like a great example, the case of how privacy changed and influences world is, for example, a recent use from Apple and Facebook, the update to iOS 14, and how it changes how the ads can be served and analyzed on the platform like Facebook or Google. So R&D, for example, in this specific case, Facebook should and probably is taking specific R&D process to find a more balanced product that will actually follow the rules that Apple placed. And from technical perspective, it should operate properly, and from legal perspective, it won't affect users. That's to wrap up about the R&D.
Okay, thanks. Now you can shoot your questions.
I think all this was very interesting, and actually, you know, the last example you were making right now, you know, the iOS updates and so on and so forth, actually drives us to the real complexity of the issue and how much it actually can affect users of any kind, and therefore customers. Gleb, I have a question. Sorry, but there is first and foremost one from the attendees, and the question is: supposing that I am notified of an access into my database from a country I'm not into, what should I do? How can I understand it was not just an IP address error, but probably something like a hacking attack?
This is deeply technical question, and I don't really want to go into these details because it will drag us down to some weird discussions. It's actually fairly simple. Like, what should you do when you are notified of something in your email from any service you're using? You actually try to see if this is a mistake or not. If you don't understand if it is, you ask your technical team to take a look into it. If you don't have a technical team, you go to a support team of the service that you're using, and you're actually asking, like, give me please actual like insight of what it is, what happened, why I get this notification. It's all about the communication, and you really don't, if you're using software as a service, for example, HubSpot, you really don't have enough access level to see what exactly happened. So you need to actually go and communicate and ask them, like, what's going on, why it's like this.
Perfect. Is there any comment to Gleb presentation from any one of you?
No,
I'm not leaving. No worries. You can ask later. That's fine. If you only did that from like a technical perspective.
Yeah.
No worries, Eduardo.
Okay, maybe we can continue, and Gleb will be here anyway for until 7 finish time, right. I assume. So we will hear more about your thoughts. But probably, if we now take Filip's presentation, and so once again, a little bit different view. So please. And actually, please, we didn't have officially introductions in the beginning. So Filip, few words about yourself too.
Yeah, hi everyone from Prague. Filip here, and thank you, Markus, for the word. I'm glad for the opportunity to share a few words with you regarding privacy compliance in startups. Since I know that privacy is not probably the top priority, I would like to share with you a few tips that may help you to avoid privacy issues in the future. Before I move forward, let me briefly introduce myself and my home organization, which is Rowan Legal. We are a leading law firm in the Czech Republic and in Slovakia. We provide our clients full legal support. However, we are highly ranked for our expertise in corporate law, commercial law, ICT and IP law, and also in the area of M&As. We are also a kind of a geekish law firm, since me and few of my colleagues are former programmers or developers. But now let's move to the main topic of my presentation. I will start with the introduction of two recent projects we were participated in that can be considered as startups. Both are from the financial sector. However, they took a different approach regarding privacy compliance. The first project is Bank ID, which is a provider of electronic identification services. Via this service, you can prove your identity to authorities or companies in the private sector just by confirming such action in your bank application on your phone. Since this project has a lot of publicity, it also attracted the attention of the Czech Data Protection Authority with their curious questions and request to provide the relevant documentation. Fortunately, this project was from the beginning led by banks. Therefore, the privacy has been solved even in the early stages of this startup. The second project I would like to mention is focused on the provision of deferred payments. That means that you can pay for goods from an online store within 14 days grace period without any interest or fee. When an investor came, he found out during due diligence that there were some privacy issues to be solved. The provider had to set new measures and change the product completely, which, as you may already guess, was very costly and time-consuming. As I tried to present you in the previous slide, if you don't set it properly from the very beginning, then it may cost you a lot of money, time, and it may be difficult to fix it in the future. Even investors can be interested in privacy compliance in advanced phases of your startup. Therefore, if you are privacy ready, it may bring you more attention from investors, and you may present it to them as an additional value of your startup. Bear in mind that it's not just about the documentation. In the beginning, it's more about the startup's general approach to privacy. Changes in staff thinking towards privacy can often be quite challenging, nearly impossible, and you will probably discuss over and over if those data are also personal or not. So how to set it right? It all starts with the approach of founders or management towards privacy. If privacy is a part of the culture and values of the company, it's much more easier for other employees to adopt this approach. Try to take it more like an essential thing of every business and less like an annoying waste of time. The core of your product or service should be designed in line with privacy standards. Believe me or not, but the documentation is not able to save badly designed product with regards to privacy. It's not just about papers. It's about the privacy by design and privacy by default approaches. If the privacy compliance is not considered in advance by the company or with the help of an external expert, it can have fatal consequences. Let's have a look at the example from the Czech Republic. There was an ambitious startup established its business on publishing real estate prices taken from the land registry. They, however, didn't notice that publishing those data violated the law. The project had to be shut down and had to be rebuilt from scratch. This example demonstrates how important it is to think about compliance in advance. Last but not least, it's important to set up processes properly. In early stages, this is usually about gaining new customers of your product. However, according to GDPR, the option to directly contact potential customers is very limited. I hope Karolina will tell you more about this topic, but subsequently, in advanced stages of your startup, you should keep in mind that you have to set effective processes on how to deal with data subject rights requests and with data breaches. In case you're still asking why it's necessary, I've got two more arguments for you. Why not to make a privacy compliance as your competitive advantage? Let's look at Apple. From the beginning, they created in-app permissions that would allow you to control your personal data. iMessages are encrypted. Apple emphasized privacy as a value that they consider important. But can it also be said about competing products? At least, I don't know, because they didn't transform the privacy compliance into competitive advantage. And that is exactly my point. And the second argument is privacy compliance as a value. Even though it may seem that customers don't really care about their personal data, they are becoming very sensitive when it comes to data breaches or misuse of their data. Therefore, privacy compliance can build trust and loyalty with your customers. And that's the end of my presentation. I take it from more high-level view, but I think that the general approach is much more important in the beginning of the startup than the documentation itself. The documentation comes to the place when you are live, when you are having first customers.
Yeah, thank you so much. Excellent, an excellent point. Why? So competitive advantage, that's a good question. That was asked also in the morning session, and we got some answers how to turn and how to demonstrate that it is. I think, yeah, it's a good question. Did Apple use it, or does it use it now? So it's a good question, but like, as you all have it, building the trust and also building the loyalty, is it at the end of the day, is it the same or partly? But really good points. Thanks. And as you said, I think we all agree that in the beginning of the startup, as Christina already asked me, is it possible to fulfill? Are they doing this? But it's, of course, if you have the culture and you ask some of those questions which I had, that's at least beginning of your data privacy compliance and turning it to support your business. So, other thoughts about Filip's?
I'd like to send big hearts.
Yeah, sorry, please.
I'd like to send big hearts to Filip because I saw the word values. And if I look at startups, everyone is very purpose-driven, and usually the entrepreneurs have these huge values that they are executing through their startup. And you presenting it that way, it really warms my heart, because I very often challenge startups. You're talking this, it has some consultant put these words into you, or is this truly you? And if this is truly you, why is this not transforming into the actions, how you are building your startup? And if you respect the privacy of others, and you respect the laws, and if you have high morals and ethics, of course you build a sustainable business from the scratch. But of course, since everyone is running a race, they want to make shortcuts. And that's where I really like to challenge the values. If you really value these things, you cannot make shortcuts. So you really have to make big choices. Where do you shortcut and where you don't? So I just wanted to say thank you very much for the word values, because that really resonated with me.
You're welcome. I think the value is much more important than the documentation you prepared and you have published online. Because if the product, if it's in the product is vested the privacy standards or privacy policies are in the product, there are no need to be described in documentation in more detail. In advanced stages of the startup, of course, but in the early stages, I think it should be vested in the product itself, but the documentation is the second or other thing.
In products and actions, actually. Unfortunately, the authorities might ask also some documents sometimes, but let's not dig in there. I don't want to sound boring here. So Christina was so happy to have lawyers who talk about values. Yeah. So other thoughts?
Yeah, I wanted to just echo what's been said, and also I think, Filip, your second point in terms of arguments for making privacy a priority is to help build trust and loyalty. I would submit that a third one is the inverse of that, which is that you've spent a lot of time and a lot of effort on getting this business off the ground, And privacy is so important to keep it, right? To that any failure of privacy, of taking into account the privacy interests of your customers. And it really is when things go wrong, where there is some sort of breach or issue or complaint, that it's just so easy to lose what you've spent so much time and effort to build. So it is just, as a third argument, I would submit, to preserve that trust and loyalty that you've developed through other areas, not even to do with privacy, that so much of it can be undermined by a lapse that could be avoided by simply making this a priority at the outset.
Yeah, thank you for your point. I totally agree. And I think it's connected to the communication. So if you have any problem, you have to communicate to your customers that there's something happening. And if you communicate, you can keep the trust of them. If you are hiding, they won't come back.
Yeah.
If I can, I think also Filip touched a very interesting point, which is sometimes the elephant in the room when you talk about data protection. You rightly said, Filip, that many customers get upset about the use you make about their data only when there is a data breach or when there is the known misuse of their data. In other words, many really click agree without reading the privacy policy. They just want to get to the service as fast as possible. They are even annoyed that they get this message about the cookies and so on and so forth. And then they are so naive to say, oh, but I didn't know that you were using my data in this way. And they get upset. So there is a bit of a schizophrenic approach, okay? We are giving up everything through our devices, literally everything. But then, we are so upset afterwards. So I think that there is a gap there. Probably communications have to fix this gap or try to fill the gap somehow between, to some extent, unreasonable expectations and to other extent, actually, what you can really claim for afterwards. And in these regards, I believe we need to sympathize with data protection authorities that have the educative goal and the watchdog goal, which is, school tutors in a kindergarten. Unfortunately, they have this very difficult role, and those actually like you who have to advise. I think something that possibly we can address at the end of the presentations of everyone is how to strike the balance. What can you really to some extent force startups to consider at the very beginning, because we're talking about an expense to some extent. If you want to have a data privacy program, you need to spend something on that. And then on the other side, which is the return of investment for that? You're talking about trust and values, which is absolutely important. You retain customers, absolutely important. So let's try to think at the very end, not now, but at the very end, okay, how much money and effort should you really put into that? So this is just a comment, but it was a great presentation indeed.
Yeah, thank you. Great. So probably we continue and let Karolina share some thoughts here. And there, before Karolina, there was a few questions. I think we touch on some, at least transferring the data out of the EU. I think Mitch will touch it partly, or at least the global point of view we discussed. So we can discuss probably around after Mitch's presentation about also the Schrems problems, etc., etc. Not too deeply, but there was what should we do? It's a simple question, but now I let Karolina, please.
Thank you. Hi, I wanted to take part in the discussion with Filip, but I had some problem with my connection. I hope it works now, because I can really resonate with what Filip said about being privacy aware from the beginning, not only because for a startup it's important that customers can trust it, but not only customers, meaning consumers, but also customers as, for example, I represented one of the biggest banks in Poland, which wanted to buy a software from the startup. The software was great. It was great for as a credit scoring product, and it was really like business people in the bank were very happy to have it. But then obviously they asked legal team, and they were very conscious about it and didn't receive many not documents, but any presentation made by the startups was about the product, but not about the legal compliance. And for the legal team of bank, it was really alarming. So because of that, the negotiations of contract took many months and postponed the start of using this product by many months. And because of that, startup has not made money for many months. So it was very negative for them, and it could have been totally better if they thought about it beforehand, came with this solutions with good DPIA, and I guess that legal team would be much happier with it. So let me just share my presentation now, and I will begin with a few words about myself. I'm Karolina Miksa, and I am a lawyer in WKB. We operate in Poland and are a similar company to Philips, I guess, because we are also having a lot of expertise in many topics. So we are quite good for different types of businesses and different types of legal advice needed. We are a team of more than 100 lawyers now, so happy to help with many topics. And I am a head of the privacy team within WKB lawyers. So let me start my presentations about building marketing databases and communication with the customers. As I have only a few minutes to present it, I would like to talk about something I called major principles of marketing communications. So that is something I want you to remember from my presentation, to keep in mind afterwards. So first principle or rule is consent. And that is, as you can see on the slide, there are 3 different blocks in which we should keep consent in mind, and it is important to distinguish between these 3 concepts. So first one is consent as a legal basis for processing subjects' personal data. Under the main European Data Protection Act, GDPR, mentioned already today, obviously, there are 6 different legal grounds that can be considered to be used for processing data. Each legal basis is equivalent. Therefore, in order to lawfully process data for marketing purposes, the company may obtain data subjects' consent. However, there is another legal basis that can be considered as a lawful ground for marketing purposes, and that is legitimate interest of the company. Particularly, when the company processes data for direct marketing, that may be regarded as its legitimate interest. The second place where you will hear about consent in the EU are the local implementations of e-privacy directive. That act is known as anti-spam laws. The directive introduced minimal level of regulation, and it's up to each member state to regulate spam on its own way. I will discuss it more in a minute. However, for some jurisdictions, it is necessary to obtain receivers' consent and implement in order to send emails or to call a person with marketing communication. And the third context in which the company should consider consent is the use of cookies on its websites. These obligations are also regulated by the e-privacy directives and are implemented differently by different member states. As you can see on my next slide, the second principle I would like to discuss is existing customer. In most jurisdictions, you need to obtain explicit consent for soliciting emails or phone calls unless that particular customer purchased your service or a product. Other scenario in which the company may send marketing communication is when commercial communication is a contractual arrangement. For example, in case there is a customer loyalty program, the company may regulate the communication as an element of the relationship with a member. It should be addressed, for instance, in terms and conditions of such program. And here you have 3 rules that should be kept in mind to communicate with existing customers. First of all, you should maintain the relationship. The recommendation is to send an email or contact the person at least every 18 months, so you can still say that there is a relationship. You should remember that the communication may be only about the service or some similar services provided, not for any other third party, for example, services. And that the third rule is to always keep opt-out clause, for example, at the bottom of an email. That's very crucial to have it in your communication. And third rule is explicit consent. That is something you may find in already mentioned anti-spam laws. It's quite practical to distinguish this 3 option of receiving consent if it is needed. First is the option that you may rely on opt-out. So there is no need to obtain a consent, but just to give customers an option to opt out. Then you have opt-in, which is an option when customer gave an active consent to receive marketing. That is how, for most countries, when you have existing customers, you may use opt-out, as I already mentioned. For example, in Poland, not. You need still opt-in for marketing, for soliciting emails or phone calls. And then you have also something called double opt-in. And that is when customer gave a consent and then confirmed it. And that is often used, for example, for newsletters, because you don't want people to sign up emails mistakenly, for example. So you want to be sure that someone who receives your emails is actually a person who wanted it. To sum up, there are differences between member states in the EU, mostly because of the e-privacy directive, which is implemented differently. And the safest strategy for marketing communication across Europe is to implement clear privacy policies and to obtain consent for different communication channels. You can use opt-out option with existing customers in most European countries, with some exceptions, such as Poland. Also, one scenario I would like you to see is this question we received from company having apps and their need to have push-ups within that app. And you can see here the difference between implementation of e-privacy directive, as we recommended this company that they can use push-ups with no restrictions directed into Polish users, as this kind of communication is not regulated by any law in Poland. However, in UK, in-app marketing notifications and messages are likely to be cut up by this legal act, and there will be requiring consent unless there is soft opt-in you can rely on. So you see that still there is many differences, and there is a hope that with e-privacy regulation that is now under drafting process, it will be much more harmonized within Europe in a couple of months. Thank you very much.
Okay. Thank you, Karolina, for sharing some further thoughts regarding the e-marketing and communications with the clients and the consents problems. So now we had a little bit further kind of digging into the legislation also around here. So today more from the point of view of the EU and GDPR, but of course this applies quite a lot of applies not as such to everywhere else, but I think same principles has to be taken into account anyhow. But regarding that, it's a good always to remember that it's not only GDPR. As you say, it's e-privacy directive at the moment, and in the future, hopefully in the near future, it will be the privacy regulation. Let's see. So, but I'm always saying that it's not that important that you remember what is the exact law or regulation, the name of it, that you remember the principles. And you remember when you, for example, need a consent. And that's like, when do I need a consent for something, especially regarding around marketing and communication? That's a good question. Is it? So, Christina, you are willing to communicate.
Well, when companies fail in these parts, we always have a lot of work. So in business-wise, I would say, please fail, because that's money our way. But on the other hand, because my first job is to safeguard the value and reputation of the company, I'd rather not work in cases like this, when these are not met. And of course, in what we do for the client, we always advise on these issues that no, you cannot do that. But if it's built in, like in an app or in the business itself, it's very much harder to sort of dig into that, because it's not sort of ours to see before it is a problem. But usually if there are any problems legal-wise in marketing and communications within the company or within the product, that's public, and that is a huge problem. Okay, having said this, I do see a lot of startups also who sees that as an opportunity to just get press. They don't really care if it's negative or positive, as long as you get press. So I do see that there are companies who are really embracing any kind of publicity, and they don't really care. But I'd like to raise a serious question around this. Is this really a sustainable way to go? And especially for investors, do you want your companies to be so business illiterate that they don't know the basics? And there's one company that has actually raised a lot of money, over 100 million euros, Clubhouse. But when Clubhouse entered the European market, everyone was like, oh, God, hey, you have serious problems. And still, that is really affecting how it's embraced or how it's taken in the European market. Even though people are using it, still issues with that. So even with over 100 million US dollars, you cannot create a company that actually understands that in European market, you have to have things in place so that it applies with the regulation. So yeah, I don't know. It's a tough thing to do. They did get publicity, but I'm not really sure if that is actually helping them or setting them behind.
There is, if I can, there is a specific question also in the Q&A for Karolina, which I will read for the sake of the recording and publication of this seminar afterwards. So the question is, Karolina has discussed a very critical point. There are completely different ways in which European Union countries are regulating the cookie sector, and not only the cookie sector indeed. When there are those situations, meaning where countries are supposed to be on the same page and framework, but actually apply these framework differently, what should a startup be doing? First question. And the second question is, should the startup tailor its policy on the stricter regulation applied within the European Union? And the third question, may the startup select the European Union country in which to work the most and focus on complying with those regulations only? I mean, these are three questions in one that I believe really represent the complexity of the subject, the complexity within the European Union, and the simple reason why PrivacyRules has not only one law firm member from Europe, but actually we have, and we try to have one representative in each European country, because it's fundamental to get not only general GDPR advice, but actually getting the advice on the laws as they are applied and interpreted in those jurisdictions. So, Karolina, this is a tough question, or the tough three questions. So your point on this.
It's very tough, and I should have thought about it before choosing my topic, but cookies is something under the strict publicity right now, not very good publicity. It also relates to the second question asked a couple of minutes before, with this Schrems II judgment and what to do with transfer to the US. This is because cookies are very related to, are very often connected with the use of these many different tools from designed by the US companies, and the use of them requires the transfer to the US. So unfortunately, I don't have a good answer to this question. If I have a client asking me that, I would actually answer with the second and third part of the question. So first think which jurisdictions you mostly direct to, which consumers are, or where are the data subjects from, which jurisdictions is communicated by choosing the language, the currency. That's not very useful in the euro, but still there are many countries not having euro. So when you answer that question, then you can think about different rules in these countries and think about using the stricter one, so you comply with all of them. But as I know from our clients, we have now one of the major cookie cases in Poland that is not very practical, and we received major opposition from the business of these clients. They hate to hear it, because the rules on cookies in some jurisdictions within Europe are just not, as they say to us, it's not possible for them. It's just very, very bad for business. But we will see many changes, I guess, in coming months. First, because of this e-privacy regulation, and second of all, as we can hear recently, Google is announcing some changes of not using cookies at all and having different technology in place. So maybe the technology is developing so fast that maybe in a couple of months we won't even have to discuss cookies. We will see.
If I can add to these two factors. Well, on the one side, promoting again the expertise of PrivacyRules members, we had a webinar on cookies in the past. So I invite the attendee who made this question to check on our website in the past webinars, because this topic has been specifically discussed. So it was a webinar just specifically on topics. Unfortunately, our website today is having problems. So please check tomorrow if everything is okay. But in any case, we have a recording there. So you can find some light in these regards. The second is possibly just a comment. Cookies policies, until such time when there will be a different framework, as Karolina was mentioning right now, from the legal perspective, and Google as a major actor will behave differently. So this might solve the problem as well. There is actually an additional aggravating factor related to cookies, which is the fact that there are some organizations, so-called privacy watchdogs, that are starting checking cookie policies of major actors and are starting reporting when they find out that the cookie policies are not in compliance with the regulations, and they are reporting to the data protection authorities. Now, this opens a Pandora box, if you want, so-called grassroots policing of these. I mean, are we entering in the sort of far west where you have NGOs or others that are monitoring and reporting to the authorities and behaving like cops to some extent, privacy cops? This might be a problem because these might violate competition laws that are particularly stringent in the European Union. So I'm not mentioning which is the NGO, and I'm sure that the NGO has the most genuine and positive intentions, but these kind of NGOs or initiatives or activities of some sort should think about the violation of competition that they might create. Because then data protection authorities might open investigations against certain companies and not others. And this is creating a misbalance. So this is very dangerous. We should reflect about this also from the values perspective that we were mentioning before. The second is, data protection authorities are in any case monitoring these. How they activate is another issue that we could discuss in a separate conference. Let's not open that Pandora box as well. But they will start, monitoring more and more, and this is an important issue to take into consideration. So possibly building up on the answer of Karolina, you might have the cookie policy of the countries where the data protection authorities are not paying too much attention to the cookie policies for the moment and focusing on some other privacy type of violations.
Filip?
Maybe I just would like to add that we in Czech Republic don't need to get consent for cookies. We have a law that allows the opt-out regime. And so if you have problems with cookies, you could focus on Czech Republic that doesn't require consent. But that should change from the next year. The legislation is on the way. So maybe we will go to the same level as the rest of the Europe in this question. And secondly, I would like to react to Andrea about the NGOs that files complaints about the cookies. And I think it's the important takeaway for me is that the NGOs monitors the websites which already uses the tools for the consent management. But the important message is that if you use the consent management platform, it's not enough. You have to set it right. The settings of the platform is the key. And you still can violate law even if you use the consent platform.
Yeah. That's a really good point. I was just that your cookie banner is not enough if your settings are wrongly made. That's a really good point, because I think in 90% of the cases they are wrongly set. The settings are not correctly. So all the cookies are there anyway, whatever you choose. But regarding this, of course, I just want to mention that we talk quite a lot of times just about cookies, but of course it applies to all technical tracking. You have to remember, sometimes you just narrow it and you think the cookies, but I use pixels, it's okay. So it's everything, it's also that. And the NGOs actually already started sending those 101 letters, and it was especially regarding Facebook pixels. And even one of our clients received that like a couple of years ago. But let's not get in there. Let's get back a little bit and I just wanted to point from Karolina's presentation, which was one point you touched, which we don't have time to discuss. What is considered to be e-marketing, what is considered to be need consent. So are those pop-ups, or is marketing in your Facebook account, is that some considered, and in what cases? Unfortunately, we can't go into details there, but of course, and it might be change a little bit in the EU regarding the e-privacy. Let's see. But there will be e-privacy probably someday in the near future, or not. And then we might harmonize, or then it will be more harmonized in the EU, hopefully. Even under the GDPR, everything's not that harmonized, but let's not get into there. But saying that, and saying already before, it's not all about Europe. Most of the startups are born to be global, and from there on we can move to Mitch's presentation. So where is actually your business? And even if you're compliant in Europe, do you have to be compliant in Canada?
Thank you, Markus. So you've heard me speak before, but why don't I just quickly introduce myself properly? So my name is Mitch Kocgerzinski. I'm a Canadian litigation and data privacy lawyer. I live in Toronto, Canada, and I'm at a national firm in Canada called Macmillan LLP, which, like many of the other firms we've discussed today, have a variety of different practice areas. I routinely advise clients regarding a variety of privacy issues, as well as data breaches in particular. But over the next few minutes, what I'd like to do is help you flag the possibility that you may unintentionally attract oversight and application of foreign privacy laws, and what that may mean for your business. And I'm going to focus my presentation here on the impact of operating an online business or e-commerce business, and what that may mean. So the internet provides new businesses with a virtually unlimited marketplace in which to sell its products and services. Now, the flip side of having that access to such a wide market is the potential to unexpectedly attract regulation and oversight by foreign governments that you didn't anticipate. And I'd like to just drill down on this point with an illustrative example. So let's just picture a simple business, a t-shirt business that operates out of a brick and mortar store located in Italy, for instance. The business doesn't do much in the way of advertising, aside from the occasional sign that's visible through the storefront window. Now, the only customers that the business has are those individuals who walk into the store, pick up a t-shirt off the rack, and walk it over to the register. The business doesn't need to collect much in the way of personal information from the customer in order to complete the purchase. It just needs to collect money and let the customer walk out of the store with the t-shirt. And the business is really that simple. Now let's picture the same business that sells its t-shirts not out of a storefront in Italy, but off of a website that is based in Italy. Now, the business is not limited to customers who happen to walk by the store and see a sign. Of course, there's no brick and mortar store in this circumstance. It can potentially attract customers from across the globe who can find the website either through Google searches for an Italian t-shirt store or referrals through social media. Now, aside from the enhanced ability that the second business, the online business, may have to a broader customer base, another key difference is the information that the business has to collect from each customer in order to process a sale. And there's quite a bit of personal information in this regard, even though it's not a complicated business. In order to sell a t-shirt, the business must collect the customer's name and contact information in order to communicate with the customer. You need to collect the shipping address in order to deliver the product to the customer, and you need to collect payment information from the customer in order to accept payment for the product. Now, the business may also collect additional information from the customer in order to promote its products or stimulate future business. Now, it's easy to see that both businesses would be subject to the laws ordinarily applicable to Italian businesses, right? So, but the second business that operates online, what about that one? Well, there's the potential that it may attract legal oversight in each of the jurisdictions of its customers to whom it sells its products, who find it online from anywhere in the world and buy its products. So this is the main issue that I want to talk about today. So let's talk specifically about privacy laws. Many of you obviously are familiar with the GDPR and that it applies to organizations operating within the European Union. And you'll also be familiar with the concept that businesses, like in Canada, that operate outside of the European Union will be subject to the GDPR to the extent that they offer goods and services to customers within the European Union. Well, likewise, businesses within the European Union may become subject to privacy laws outside of the European Union. Now, I'm from Canada, so if I may, I'm going to offer an example about how Canadian privacy laws may apply to your business. Canada's privacy regulators just considered recently whether Canadian privacy laws apply to foreign businesses in the context of Clearview AI's controversial facial recognition tool. Now, for those of you who are not familiar with Clearview's business, it's an American company that offers facial recognition, a facial recognition application that allows its customers to quickly identify people in an image. Clearview's service works by scraping billions of images of individuals around the world and creating biometric identifiers for each person. Well, the Canadian privacy regulators examined this practice and did an investigation into whether or not Canadian privacy laws applied, and having found that they did, made various other findings. So the Canadian privacy regulators determined that Canadian privacy laws applied to Clearview's business, an American business that didn't have any physical presence in Canada. Now, in reaching its conclusion, the regulators considered, among other things, that Clearview marketed its services to Canadian customers through promotional material and Canadian testimonials. Now, applying the same principle to our Italian t-shirt store, the business could be found to market t-shirts in Canada by, for example, targeting advertisements to Canadians, generating social media content aimed at customers, or potentially making products available for shipment to Canada. Now, consider the social media point. I mean, you may have social media posts by celebrities or individuals that are well known that may have reach into Canada, and that may provide that sufficient connection. Now, if privacy laws apply to your business, Canadian privacy laws apply to your business, that business will need to make sure to have Canadian compliant privacy policies and know and understand the unique privacy obligations that exist in Canada, for example, regarding data breaches. And one point, because it relates to the information that we just heard about the GDPR, that I think is notable to bring up here is that Canadian privacy laws differ from the GDPR. Now, a lot of people may correctly assume that the GDPR, if we comply with the GDPR, which is perhaps a more strict regime, then we must comply certainly with other laws around the world. But that's not entirely accurate. And I'll just give one example. While the GDPR provides for various legitimate interests that would enable you to process personal data, in Canada, consent is key. It's a consent-based privacy regime that really does require consent as the primary interest and authorization in order to process information. Now, the point that I'd like to leave you with today is that while leveraging an online platform can drastically expand the marketplace for your business, it's critical to proceed with caution and to keep in mind that you may inadvertently attract the application of privacy laws of other jurisdictions, which may be different than the GDPR. And it's for this reason I say that it's critical to develop an understanding of applicable laws to which your online business may be subject to in order to avoid unwanted consequences down the road. And I touched on this earlier just in my comments before. So how can we do that, right? I mean, part of it is going to be looking into your business and what it is that you do. Who do you offer your goods or services to? Who are your customers? Another consideration is what other personal information might you be collecting, whether it's from investors or not necessarily your end customers. And then who are you relying on in terms of subcontracting out certain services, whether it's your payment processing, with an e-commerce platform, or who's sending mailings if that's something that your business does, whether it's through a newsletter or otherwise, or who's dealing with your shipments of product across the globe. It will give you an idea of what privacy laws you actually may be attracting in order to ensure that, while business is thriving in Italy, you may all of a sudden wind up with a privacy complaint elsewhere in the world, whether it be Canada or otherwise. And of course, being Canadian, I use Canada as the primary example, but certainly the same would be true of other jurisdictions potentially as well. So that's that's the bulk, the meat of my presentation. However, I'm more than happy to continue to discuss and respond to any questions that may arise from it.
Yeah. So, questions regarding and around this, especially it's a tough question, of course. So I think it was even our shorter Privacy Espresso discussion that the subject was touched upon. So if I have one customer from Canada, do I have to, and I provide my e-commerce from Finland, do I have to fulfill with all Canadian laws?
So, I mean, the answer technically, of course, would be yes. I mean, if you're processing information about a Canadian, you will have to comply with the Canadian legal regime with respect to the processing of that individual's personal information. Now, I think that it in particular, if you're advertising to Canada. And again, I say Canada here, and you can apply this to other countries. But if you're trying to get business from Canada and you're trying to avail yourself of this sort of broader marketplace, it's certainly important. I'm not saying that you all of a sudden have to develop a privacy policy tomorrow that deals with every single country that anyone can access your website from. However, it is worth giving thought. And meaningful thought to where do you want your business to grow, and then what are you doing to avail yourself of certain customers across the globe? And frankly, if the risk is too much at the time, then there's various mechanisms that you can consider and discuss in order to sort of hive off and avoid operating in certain jurisdictions if you wanted to. But if certainly the objective is to grow, then it's at least worth spending a little bit of time as early as possible in order to understand what some of the key differences may be with the various jurisdictions in which you hope to sell to.
Yeah. So in principle, yes, but in practice, maybe. And you have to follow and of course analyze the risk and etc. etc. But of course, yeah, thanks. It was a good answer. So did we have other questions?
If I may, Markus, I mean, yeah. I think like everything in life, it's a matter of making initial assessment with experts who can drive you through the various kinds of costs. I mean, I think that in the panel here, all possible spectrum of costs are emerging. So live costs for legal advice, for technical research and development, for communication, the costs of losing the customers, the costs of being investigated and fined. This is also to build a little bit on what also Karolina was mentioning before. there are a lot of automation services related to privacy. There are a lot of companies saying, come to us, or better to say, we come to you, we install our software in your networks, in your companies, you use that and you will comply and you can sleep relaxed. That's not true at all. The real check and balance can be done also by human intelligence. People sitting with you and discussing with you, okay, you want to open a new market. What do you have to do? Which is the minimal decision you have to take at the very beginning? Which are the costs on the way? Which are the increasing risks the more you grow in that market? And then you make a reasoned decision. Okay, you will take a bit of a risk at the very beginning, possibly. We were discussing about shortcuts. So you can accept, okay, this is what I will do now to penetrate this market. But this is what I have to know that in 3 months from now, 6 months from now, I need to start upgrading my level of compliance. I need to start making strategic decisions that will allow me to grow there. Because otherwise, if I get breached, if I get investigated and fined, then I lose not only that market, but possibly many others. Because my competitors will start saying, okay, I didn't comply in Canada, probably I don't comply not even in Italy, to remain in the case of Mitch before, and other countries. And so you start losing customers all over. And possibly your investors start abandoning you as a cascade effect, and so on and so on and so on. So you need to sit with experts. You can use automation to a large extent, but then there is a limit. And so this is actually what I believe is quite important.
Andrea, we should thank you. We should leave some room also Christina's presentation. So probably, sorry interrupting you, but yeah, definitely. The only problem is, of course, the online world. I'm approaching Canada, but getting all my clients from Italy. I didn't even want to go to Italy, but everybody's buying my T-shirts from the Italy. So it's like, this is also the problem, but we can't solve everything today. But of course, you should know, and the areas you focus, invest also in data privacy. So it's like, it's key importance there. But probably we'll let Christina share some thoughts. Of course, we had one question regarding the data transfers. Should we touch it now or?
Yes.
Probably regarding because it's a quite hot topic. And then there was a good question how you can build trust out of your privacy policies, which was, but probably that Christina could share some thoughts around that too. But regarding the Schrems question and data flowing out of the EU, of course, we can choose the service provider from Canada. Data can be transferred to Canada. It has an adequacy decision, if I'm correct, regarding the business connections. But how otherwise? Your thoughts? What should we? Schrems decision. Many of those U.S. service providers are not compliant with GDPR. And should not be used. We cannot move from them. What should we do? So, not having the customers from other countries, but having the service providers from out of the EU. Filip, do you have a turnkey solution for this?
There's no universal answer for that question. I think that when you trying to focus on some market, then you have to comply with their law. If you are doing it unintentionally, if there is a customer from the country you didn't choose you to be the one you focused on, you don't have to care too much about the privacy and the privacy regulation.
How about your service providers? If you use services which are out of the EU, cloud services for running your e-commerce site or running your customer bases, you use MailChimp, for example.
Yeah, Czech Data Protection Office is not that strict as the German Data Protection Office is, since or therefore the usage of this service is not limited in Czech Republic. However, you should probably conclude any addendum that those services provide, which provide following or additional measures or organizational or legal, for example, as Amazon does, that you can conclude with those providers that may threaten your position in case the Data Protection Office will knock on your doors.
Yeah, and of course that's a huge question, and unfortunately we don't have too much time for that. But anyway, if you use service providers out of the EU, you should do something, and you should analyze the situation. If you use US service providers, you should do even more at the moment. And it's a different approach, even inside the EU, from the authorities, how strict they are. But let's dig into that question also in some other seminar, Andrea. Should we do so? And international transfers, actually, we did it already for a while ago. But now, Christina, you are the last but not least, or how do they say it? And communications, and back to the values, communications, and world around the legal and tech matters.
Okay, thank you very much. I think that for everyone's sort of understanding of the complexity of let's say a digital startup or a startup that has global issues, like Mitch was sort of saying, what are the differences between having a brick and mortar business and having a digital business? And the digital business, of course, makes the ballpark very, very big. It's the globe. So usually communications is considered as something that you do when you like or when you choose. But the problem is that if you fail in business, people will talk about you, whether you talk about yourself or not. So you're dragged into a discussion. For any startup to actually start their career in public, in the media or in public discussion with the wrong note would be quite devastating. So doing the right thing from the beginning is really the essential business skill that you need to have. So I think it's really important that we understand that we are not talking about something that you can opt out. And like we were talking about the shortcuts, at least you need to know what shortcuts you are taking and not just step into one problem after another. And during my career, I have seen a lot of startups doing everything wrong from the beginning and of course failing. And usually when they come to our business asking for help, it's usually because they need to communicate something urgently to someone. So it's always about reputation, building reputation and building trust. Where Markus started, it's about building trust because nobody wants to be involved with someone who's not trustworthy. So there are lots of things that you need to consider when you start building a business and you want to make it sustainable, if you want to make it last for a longer period of time, if you want to create value. The sad thing is that usually all these things that we talked about here today, legal aspects, technical aspects related to legal aspects, and all of this tied to how do we communicate with our stakeholders, all of these together tie up into what I just call business knowledge and business skills, because that is what your business is all about. But I'd like to leave you with a very, very positive note and share you sort of the concept that when you have totally shortcut or omitted all these things and you run into problems, you might want to ask if there's still a place to save your ass and save your investors' asses and look into the problem. So I'd like to share a sort of a concept that sorry, I'm just going to put it out there. A concept that sort of clarifies, at least for us, I hope it clarifies it for you as well. So when you have not taken care of these things beforehand, making sure that your tech is reliable, making sure that your legal obligations are met, and making sure that you understand all the stakeholders involved. So about cyber security, privacy, all of the privacy breaches, security breaches, those are things that we now always say that it's if it happens, it's when it happens. So when it happens, at least you should know this, that there's a way to look into any crisis or any situation, or even it doesn't have to be a crisis, but it can be an alert that alerts you to act and look into the situation in more deeper level. So you need to have this business-oriented approach to make sure that you safeguard the value and the data. Actually, the value is in the data, in the trust of the community that you serve. The business-oriented model is sort of three-folded, but it has the black box that you can see. It's the sort of the governing state of everything. It's the gold team looking into what the situation is, what we should be doing, how should we communicate, premeditated agreements on management systems, resources, make sure that we have all the resources and we have the infrastructure to take care of the specific situation. But I'd like you to sort of think of all of these questions that are here now. In every case, you need to ask yourself, whose trust is vital to us? Whose trust is vital to our business? That is the only question that any business should be asking. And because of that trust, that is a currency. That is the only thing that actually matters. You have to think of all the stakeholders, and therefore you have to think about reputation. How do you manage your reputation? And to be really clear about this, reputation is not what you say about yourself. It's what others say about you. Brand is what you say about yourself. So, and then we talk about corporate social responsibility. And now if we think about corporate social responsibility, that ties very much to the values that you want to represent as well. So it's all about demonstrating in your service and in your business what your values are. Business continuity. A lot of businesses fail if they end up losing in these areas very, very easily. Business operations and communications, how do you deal with these all the time? So there are lots of stakeholders that you need to cater at any given time. And I think it's really, really important if you think about the privacy issues as well, that you understand that when you manage all the stakeholders, you're also managing very, very crucial data. And the whole ecosystem that is involved with you, they are all alerted if something is happening to you. So either they are your friends or they are your enemies. And you want them to be your friends at all times. But to understand how this all ties together, I think it's really important that we understand that in any situation, any given situation, it's wise to have all these disciplines communicating with one another. And as much as I love lawyers, I really appreciate lawyers' work, they are most of the time very, very difficult to understand. And therefore, I sort of encourage people to work with the communication part as well. so that there's the legal framework, there's the legal requirements, but there's always someone to interpret what does that mean and question. Because when we have agreements, when we settle for things, a lot of times people say, well, I signed the document, but I don't really understood it. I didn't understood it. I did not understand it at all. So I think it's really important that we actually allow ourselves to be very human, and also making clear about what it is that we want to communicate and what we are actually trying to achieve. And legal documents are really, really hard for anyone besides lawyers. I think a lot of times lawyers even say that they are very difficult. And I like to share that my very good friend is a lawyer in New York, and she actually was hired to look into agreements for other lawyers for grammatical mistakes. And not that I'm very much into grammatical things, but because you have a comma in the wrong place and you have a serious problem. And that's why it is important that even lawyers know where the commas should be and even the full stops. So I think it all ties into putting all this talent together and making sure that we look these issues from very, very different perspectives, because first of all, we have to tackle very, very complex issues, very different markets, and very different kinds of stakeholders. And all of that increases the complexity of not getting it right. We don't have to get it 100% right, but I think we are in much better position if we understand that all of these need to work seamlessly together in good times and in bad times. And yes, you can prepare for these in advance to make sure that your tech is okay, your legal framework is okay, and you have the communications part that also is prepared for any kinds of situations that you might be facing.
Thank you, Christina. And this is really good. This is actually where we started from. So it's not only legal, it's not only tech, it's not only communications, it's all together. And it was a good point also that even if you wouldn't, if you were not fully prepared, even afterwards something can be done. So, but you have to still remember all these different angles of the problem, hopefully. And unfortunately, the risks are real, and it's not a question about if it happens, it's a question about when it happens, because
yes. And you, Markus knows that we have been dealing with these kinds of issues together also. So I think it's fair to say that yes, a lot of times you would not have these problems that people have if they had prepared or if they had thought about things beforehand. But still, I'd like to assure you that if you work early on and you're very open about the situation and you assemble the goal team to operate in a crisis or let's say in a difficult situation, you can still save it. It's not easy, but it can be done.
So this is a really good discussion. I think we could continue a couple of hours more here and really good questions. Unfortunately, I think we do not have time to answer all of those. I don't know, Andrea, if you will keep them or we have these other possibilities to share some further thoughts. But you were willing to us to have, because I think we have like 6 minutes or something like that.
Would you like to answer that question? That there's one question I'm not really sure I answered that.
Which one of those? I think there are.
What is the best way to communicate with the customer base when it comes to privacy matters?
How exactly. Can you build the trust? That was a good one. Yeah, there are even more questions, but you can answer that.
Well, I can definitely. It's not only what you communicate with, but how you set up your service and how it actually works. That's like the strongest your deeds actually communicate best. But another thing is that try to write the privacy policy in a way that normal people can understand it. And that requires, I think, a lawyer and a communications person together. I think when we are put together, we can actually provide a lot more information and a lot more comfort to people, because there's the human aspect is there as well. And I think it's really, really good. When I wrote our privacy policy, I was really thinking, I started with, you are in our database because we have a relationship. That's how I started it. So there's a clear reason why you are in our database. And I think I continually started thinking, well, I'm talking to someone who is trying to figure out why and how we are using our data and why they are there. So be human.
So really, and actually that's what GDPR says. It should be written so that everybody understands it. And too much is not good. You can know this from the Google decision. If you have privacy policy, how much, 40, 50 pages, it's a bit too much. You won't survive in the middle there. And I can know this. Sorry?
Pardon me. No, pardon me.
Please. Yeah, Mitch.
Oh, I was simply going to add from the extra European Union perspective that again, the privacy policy has to contain a lot of information. Can it contain every piece? Well, the more that we put in, the more complicated it gets, the less likely that any of it will be read and appreciated. And what we're trying to do is also balance the user's expectation, the customer's expectation, a reasonable expectation. So what we do in Canada, what our regulators have suggested, and in fact, it's critical to obtain meaningful consent, is have a highlights section or a way to emphasize within your privacy policy, well, what is the, at a glance, your customer need to know? And what we do, and what we recommend doing at the outset of our privacy policies, and again, a lot of this is going to depend on how a user actually interacts with your policy, is to emphasize those key issues right up top. And what those key issues are, from the Canadian privacy regulators' perspective, are what personal information is being collected, why is the company collecting that personal information, how is it being used, who's the information being shared with, what are the risks, and if there's anything else unique to the circumstance that ought to be known. We just have bullet points on each of those issues so that at a glance, your customer knows, what do I need to know, and where do I get more details if I really wanted more detail.
But it's like building your e-commerce site. You want that everybody understands it. I'm willing to buy. So why don't you build your privacy policies in the same way, so that you're willing to have the interaction and the actual knowledge about what's happening there? Of course, sometimes we don't want to, but it's a different question if you want to use all those dark patterns, etc., etc. Andrea.
Yes, Markus.
The final words. We have 2 minutes.
We really have 2 minutes, and I'm so sad because we have so many other interesting questions there. So I invite everyone. There are some questions that are anonymous, some others are not. I invite all of you who have put questions here to please send them to info@privacyrules.com, and we will answer your question. Evidently will not be public, so it will not be for the benefit of the others in the attendance, but we will surely answer your question together with our experts. So please write info@privacyrules.com. There is 1 minute, but I would love to receive just one takeaway from each of you speakers. And thanks in advance, every one of you, for being here, and Markus in particular for co-hosting this event and for moderating this event. One takeaway can be a consideration, a practical tip. As we said at the very beginning, it's a very difficult balance for a startup. What to prioritize, how much to spend, what to do. On the basis of your experience, can you say in really 20 seconds your main takeaway for those in attendance here? Let's start from Christina, Karolina, Mitch, and Filip.
That was a bad one. I would say that trust yourself and always think of how you can build trust among all the shareholders or stakeholders whose trust you actually need, because that is the key to any success.
Thanks a lot. Karolina.
Don't think about privacy as a cost, but as a value and as an asset that can be presented to your customers as such, so they can trust you and rely on our products better.
Super. Mitch.
Understand that when you are operating online, you may touch upon governments and rules that you don't anticipate. Understand where you're doing business and where you want to do business, and also that trying to comply with those other laws doesn't necessarily mean a complete rework. It just means a little bit of focus and adaptation. So the cost doesn't have to be start from scratch. In fact, it's possible to supplement what you've already got.
Thanks a lot. Filip.
Try to take privacy more like an essential thing of every business and less like an annoying waste of time. It can be a business differentiator and maybe a breaking point of your business that could give you the competitive advantage.
Wonderful. Markus, you have it from Lexia perspective.
I think I'm sharing Filip's thoughts, and I'm just saying that data is crucial. Don't mess with your data.
Let me conclude by reiterating, we are here to help you. PrivacyRules, its experts all over are here to help you. The many of us, I would say probably the majority, have a special startup programs, meaning that they are ready to help you at very favorable conditions, even talking about price, that is often a kind of a free legal or communications or cyber counseling at the very beginning, just to understand which are your problems. And then, you don't have to spend up front. So please come to us, come to our experts. We are launching a series of new products, and we will also include the one related to startups over there. So in about a month's time, you can discover much more on our platforms, and please follow us on all our social media to learn about the next initiatives and also the past ones, because we already have a wealth of knowledge that we can share with our seminars, webinars, and so on and so forth. I believe that when we will be publishing these seminar, we will also send out some info notes, infographics, summary about it, a report, so you can actually have some takeaways even in writing. I believe that also the PowerPoint presentations of our speakers can be disseminated there. So you will have also additional information from them, and you can bring home, you can bring to your buddies, to your boards, etc. So thanks a lot for being there for such a long time, and thanks a lot for all your questions. Send them over to us, and let's stay tuned. Thank you.
Thank you. It was a pleasure. Bye.